true. As decided by all the parties, may this matter be taken up in the month of February.
You are the petitioner.
Yeah, petitioner. Mr. President.
Consent taken.
Yes.
Heard
We
Miss-
already decided to take up in the month of February.
Oh, why? There's no
Because-
this thing. Some development in between. Are you expecting some?
No,
Development?
it is not like that, because there is some unavailable circumstances.
Okay. Heard Miss Jacinta Zothanmoy, learned counsel for the petitioner, who has prayed for adjournment of the matter with the consent from the other side. Stop. As sought for new para by the learned counsels for both the parties, list the matter during the month of February 2026. Yes.
Mr. President.
May it please your lordship, I seek indulgence in mentioning item number 6 of the part 2 hearing this, your lordship. I've taken the consent of the other party,
Yes,
lordship.
Mr. Tilal Zakim is also here.
Yes, your lordship. If this matter may be listed again after the vacations, your lordship.
Okay. Ms. Lalnunlui, learned government advocate for the state respondents, have prayed for adjournment of the matter, which is not objected by Mr. T. Lal Zakima, learned counsel for the petitioner. In view of the above, list the matter after the ensuing vacation. Yes.
Much obliged, your lordship.
For motion, item number 1.
Yes.
Lordship, yes, this is the electrocution case. Yesterday, I was allowed to produce the Apex
Yes.
Court ruling regarding the maintainability
see,
of the writ petition, Lordship.
My concern is there could be some disputed questions of fact. If
Lordship,
there is any disputed question of fact,
Lordship, yes.
then it has to go before the civil court.
Civil court, very true, Lordship.
And it appears to me that when you had previously filed your the matter before the civil court and the written statements were made, there were some averments regarding the question of fact which was denied. In the written statement, I think the state respondents had mentioned something about evidence required to be taken. They denied some of the submissions before, when it was filed before the trial court. Okay.
Lordship.
Thereafter, you withdrew. So I just wanted to make sure.
Sure, Lordship.
So you withdrew from the civil court and with a permission, and then you came as in the form of a writ petition.
Lordship, yes.
So at the time of considering the writ petition, if you consider the submissions made by the defendants, that is in the lower court,
Lordship, yes.
they are denying some facts.
Lordship.
Then if it's a question of fact, then you
What they
cannot
have denied
consider-
is their deny liability, P&E department. Here they says that it is submitted that although the line belongs to P&E department, however, the alleged accident was due to encroachment of the line by the PHE building and sending a person to dangerous place without taking necessary precaution by the employer and without informing P&E department to shut down power to avoid accident. That is the only.
Anyways, we'll issue notice.
Also,
If
yes.
there are some questions of fact which have to be looked into, then
Very
we
true,
can
Lordship.
this thing. Is
Your
it?
lordship, if I may be
That's
allowed
the
to,
only concern, huh? Yes.
if I may be allowed to make a certain
Huh?
submission, your lordship. I have 2 judgments which I may be allowed to produce before the court, your lordship.
So no, it should go before in such matters.
Lordship,
It should be placed before the
Civil court, your
civil
lordship.
court if there are any questions of facts to be looked into and evidence is required.
Lordship,
If
yes.
not, some of the matters can be taken up in form of a writ petition also. Okay, there's no bar because it can be done in both ways. So that's why I'm asking. No,
yes.
I'm just concerned because you first filed as a civil suit. After receiving the written statement, you withdrew and came before this court.
Lordship, yes.
So are there any questions of fact which have to be decided with evidence required in the lower court? That's the main thing.
Lordship, that was not available. The reason why we have withdraw is that we are inadvertently not implemented the PHE department. That is the
Okay.
only reason, Lordship. Others are very clear, Lordship. There is undisputed fact is that the deceased died due to electrocution. And I have annexed the engagement letter, medical report, police report, everything, Your Lordship.
Anyways, we'll issue notice.
Lordship, yes.
And then at the time of issuing notice, we will also look into the issue whether the question should be, this matter should be first decided by the civil court or not. You have a look at this thing, isn't it?
Lordship,
So we'll keep that issue
maintainability, we keep open,
open,
Lordship, yes.
because if someone is hurt, burnt badly, he died or what?
He died, Lordship.
Died, then he is entitled to some compensation. We shouldn't keep the victim in such matters awaiting for. When was the accident?
Accident is in
Awaiting to be
2000, yes,
compensated.
2016, Your Lordship.
So if it can be disposed of in a quicker, faster manner, it's good. But we'll see. I'm also a little bit doubtful whether it can be considered here if there's any questions of facts which are to be decided. Anyways,
Your Lordship, if I may,
yes.
if the matter is being admitted in the High Court, Your Lordship, then we would have to look into subject of limitation as well and other legal principles.
Yes. Limitation.
Lordship,
But writ petition, there's no limitation
Yes,
period for
Lordship.
a writ petition. Okay. So you, in your this thing,
yes, they have to file the affidavit, Lordship.
in your counter, if you want to raise this, okay, no limitation period, but then if it's prolonged without any explanation, you can raise that also. Then in their rejoinder, they can explain if it's
Lordship,
required.
yes.
Yes. Heard Mr. Johnny L. Tautong, Learned Counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or direction to the respondents on the grounds that the petitioner is the legal representative of being the paternal grandfather and the legal representative of the deceased Joshua Lalming Thanga, who died on 16/02/2016 due to electrocution while working as a daily wage laborer on the rooftop of PHED building at Tweekwatla, has not been compensated by the respondents till date, though the respondents are responsible for the death of the deceased Joshua Lalming Thanga. Notice be issued to the respondents. Ms. Lal Nundlui, Learned Government Advocate, accepts notice on behalf of the state respondents. No need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the Learned Government Advocate. List after 3 weeks.
Much obliged, Lordship.
Much obliged, Your Lordship.
Item number 2.
Yes.
May it please Your Lordship, additional affidavit incorporating the new developments was filed, my lord.
Additional. Then what is the matter about?
The matter is regarding the
Compensation.
compensation which has been awarded has not been released to the petitioner till today, my lord. Check was issued by the respondent number 4, Kala. However, the check expired. The bank requested the DC to reissue the check again, but no steps has been taken till date. Hence, the petitioner is left without receiving the compensation, my lord, awarded to him till date.
Okay, heard Ms. Valentina K. Laldenpui, Learned Counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or order to the respondents. Full stop. The Learned Counsel submits that the land of the petitioner, only one petitioner,
My lord,
okay,
only one.
The land of the petitioner was acquired by the respondents for building, maintenance, management, and operation of NH 102B in the stretch of land from KM 0 to KM 122 in the district of Saitwal. Full stop. Accordingly, compensation for the compulsory acquisition was awarded to the petitioner vide 3G of NH 102 capital B, comma, package Roman 3, comma, part 2, Roman 2, within brackets, Saichal and Rule Tom, close bracket, on 21/11/2022. However, though the compensation was awarded, however, the said compensation amount was not received by the petitioner till date, compensation amount amounting to 24,60,874 was not received by the petitioner till date. Full stop. The petitioner had also inquired about the matter, wherein he was informed by the district Kala, is it,
My lord,
that the said amount was debited, the said amount was deposited into her bank account at Mizoram Rural Bank, comma, Hyalpui branch, is it? Hyalpui branch. Full stop. When the petitioner inquired about the matter, she was informed by the branch manager. Where is that?
in the additional affidavit, my lord. Page number 9.
Is it the branch manager? She was informed by whom? She was informed by the concerned bank, that is what?
Indus Ind Bank.
Indus Sind Bank Limited, Aizawl branch, that the previous check issued had expired and no check has been issued by the Deputy Commissioner till date. Full stop. In view of the above, since no monetary compensation was received by the petitioner, the instant writ petition has been filed. Full stop. Issue notice. Do we need to issue notice or inquire, get instructions? And we'll issue notice first.
Yes, Your Lordship, and another thing is that I'm not representing Kala. I'm representing the Revenue Department.
Issue notice to the respondents. Ms. Avani Isyami, learned government advocate, accepts notice on behalf of the state respondents number
2 and 3.
2 and 3. No need to issue of formal notice to the state respondents. Notice be issued to respondents number 4. How many?
4 only, my lord.
Okay, to respondent number 4 through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks. Yes, why is this thing, Samuel, standing? You are for respondent number?
5 and 6, ma'am.
Okay. So just before issue notice, before that, Ms. Vanesiami, Government Advocate, except not 2 and 3, and Mr. Samuel S. Vanlal Shiata accepts notice on behalf of, yes, respondents number
5 and 6.
5 and 6. Then no need to issue phone. Then rest after 3 weeks.
Obliged.
Item number 3.
If it may please the court, my lord. My lord, there is a case where the petitioner, my lord, who is an associate professor of the Mizoram University, my lord, has applied for CAS promotion, and her application was accepted, my lord, by the screening committee. It was approved and it was sent to the selection committee for interviews, my lord. And the decision of the selection committee, my lord, is impugned in this writ petition, my lord. And if your lordship will turn to page 199, my lord, this is the decision of the selection committee,
199.
my lord, yes.
But your promotion is due, you're saying. How is it due?
So, my
Are you
lord,
entitled to be promoted?
yes, because CAS promotion, my lord, is career advancement scheme promotion.
What is,
So it's almost like the ACP, my lord. It takes you to the
Okay.
professor. So it's not competitive in that sense, my lord.
okay,
this is the-
199.
yes,
huh.
this is the decision, my lord. It says like this: the selection committee not recommended the petitioner, the promotion of Dr. R. Chong Sang Pui to professor under CAS. Now that's all it says, my lord. Now, in this respect, my lord, I
But
would
how
like,
much can they write? The space is very less.
that is true, my lord. But if your
So
lordship
maybe
will,
you're not required to give a elaborate reason.
no, my lord, if your lordship will turn to page 145, my lord. This is the rules and the regulation with respect to the promotion, my lord. Now, these are the UGC notifications. In fact, this is also part of the UGC Commissions Act 1956, my lord. In the short title, it says all of that, my lord. I'll not read the short title. But if your lordship will come to page 151, which is part of this particular document, my lord.
Yes.
Now, my lord, your lordship will see the serial number 5, bottom in the middle, my lord.
Yes,
Serial
yes.
number 5. If your lordship will see, it says 50% research contribution. And then it says 30% assessment of domain knowledge and teaching practices, and 20% interview performance. So the interview, my lord, carries only 20%. But in this particular case, my lord, the entire 50% and the 30% has been ignored, my lord. And in this respect, my lord, to give context to this case, my lord, I have one judgment of the Madras High Court.
But see, you're demanding to be this thing promoted, isn't it? Is there a limited number of sanctioned posts or something, and the most eligible one is promoted, something like that?
No. There is no sanctioned post, my lord. This is like ACP scheme. It's
Okay.
where your pay gets upgraded and you get the title of professor, my lord. So there is
Okay.
no particular sanctioned post.
So
It's a type.
50%, 30%.
Yes.
Okay.
And 20%. And my lord, I have a judgment produced. My lord,
Yes, I have it with me.
Oh, yes, my lord.
So you are saying that you have scored the required 50% and 30%.
Definitely, my lord. That is why we have been recommended for interviews.
Okay.
And your lordship will see page number 11.
11 of the judgment.
Yes, my lord. This is particularly very similar to the case at hand. My lord, from paragraph number 24.
Yes.
It says like this: there is no quarrel that the petitioner possesses the above eligibility conditions, my lord. The screening cum evaluation committee had screened and also recommended her case, just like our case, my lord, as having in possession of the minimum research score of 110 as per appendix 2. My lord, we have 545 in this, not 102, 545. Thereafter, she should possess a satisfactory or good grade in her annual performance assessment report for at least 2 of the 3 years of the
So
assessment.
do you have this?
We have all of this. That's why we have been recommended for interview, my lord. The same is also not in dispute between the parties. Therefore, she was included in the final stage that is to be recommended by the selection committee, which is constituted under the regulations. The said committee, as per the counter affidavit and as per the records which are produced before this court, seems to have interviewed, my lord, we were interviewed, the petitioner on 11/2/2022. In the information originally furnished, certain portions of the minutes of the selection committee meeting were redacted, and what was provided to the petitioner is that the information that the selection committee on evaluation based on the interview of the candidate, Dr. T. Sumathi, Associate Professor, Department of Medical Biochemistry, found the candidate not suitable for promotion to the position of professor. The portion that contains the names of the experts who were interviewed and the signatures of the experts were redacted, and it is essential to extract the minute furnished to the petitioner in the picture format, which is as follows. Now, it's not there in this one, my lord, but paragraph 26. This apart, as a perusal of the records which were produced before this court, apart from the above one sentence, it can be seen that one expert member who participated in the selection committee proceeded through virtual mode, had submitted his remarks by email, which reads as follows. I will not read all of this. 27. There are no other endorsements in the minutes of the selection committee. The other members of the selection committee have not recorded any independent views, and all of them have signed with the above one line that the candidate is not recommended. Thus, it is clear that the selection committee had interviewed the petitioner, and in the interview, the petitioner had not satisfactorily answered the questions which were posed by the external expert members. Therefore, the selection committee has not recommended the case of the petitioner. Whether such a procedure adopted by the selection committee is in tune with the regulations extracted above is the question that begs an answer. Firstly, it can be seen that the entire purpose of regulations, if read as a whole, is to provide objective standards and criteria resulting in a transparent method of selection. On a reading of Regulation 6.4C4 extracted above, it can be seen that the constitution of the selection committee as such is mandated by the regulations. My lord, this is the UGC regulations. To that extent, the selection committee is rightly constituted as per the regulations. On a reading of Regulation 6.0 I extracted above, it can be seen that the selection procedure shall incorporate a transparent, objective and credible methodology of analysis of the merits and credentials of the applicants based on the weightage given to the performance of the candidate in different relevant parameters and his performance on a grading system pro forma based on Appendix 2, Tables 1 to 5. 29. Regulations further categorically state
So,
that
no, so what is the conclusion?
so the conclusion, my lord, in this case was that there has to be a reselection process.
Okay.
So, my lord, we are also
No, will issue notice, let's
Certainly,
see. What do they have to say? But, Mr. Joseph Lalsan Himaranti, Learned Counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or directions to the respondents by challenging the denial of the, what's the full form? CAS?
Career Advancement Scheme.
Career
Advance.
Advance Scheme,
Yes, my lord.
within brackets, CAS, promotion to professor after the interview held on 28/03/2025, wherein the minutes of the meeting simply stated, open inverted commas, not recommended, close inverted commas, without giving any reason, along with the resolution of the 68th Executive Council held on 14/07/2025, and the, what is this resolution?
My lord, this resolution was to approve the selection committee decision.
Which had approved the decision of the selection committee and the impugned order dated 28/07/2025. What is that?
My lord, this is the final promotion, my lord, for different people. So,
Which is the final promotion wherein the instant petitioner has been excluded. Full stop. The learned counsel submits that the petitioner is entitled to be promoted since She has, where's the thing that you showed me regarding 80%, 20% of the
My lord,
page?
at page 145, that's the beginning, my lord.
So that portion which you read out, one?
My lord, that is at page 151. It's Appendix 3, Table 2A.
Submitted that she has all the required qualifications to be promoted, since she has acquired the 50% research contribution and 30% assessment of domain knowledge and teaching practices mandated under, what is
My
this?
lord, this 50% and 30%, my lord, let me explain because, my lord, I don't want to make a mistake
I
here.
thought that was,
No, my lord, what it says is 50% and 30%, my lord, of 100%. They have to consider, like 50% of the entire 100%, my lord, is with respect to research country. In other words, it's
Okay,
not
wait, 30% research and 50%, and only 20%
For the
was
interview.
reserved for the
Correct.
interview
Correct, yes.
performance. Full stop. The Learned Council submits that the petitioner, being not considered for promotion without giving any reason for her rejection, is not as per the principles of natural justice. Stop. Okay, we'll just end it like that.
Yes, madam.
Issue notice to the respondents. Miss
Rutler Watfeli.
Rutler Rotfelli, Learned Council accepts notice on behalf of the
All the respondents,
on behalf of the respondents. No need to issue formal notice. Requisite extra copies of the writ petition to be duly furnished to the Learned Council. List after 3 weeks.
Obliged.
For admission, item number 4.
My lord, in this case, there is a newly impleted respondent number 8.
Yes.
As per the order of this court on 17/10/2025, he was impleted, and thereafter today a notice has to be issued to the respondent number 8.
Okay. So you had made the corrections.
Yes, my lord, I have replaced.
Okay, Mr. Silal Fagzwala, Learned Counsel for the petitioner, submits that he has made the necessary corrections in the writ petition in terms of this court's order dated 17/10/2025, wherein the newly impleted respondent number
8,
8.
additional deputy commissioner Kamkala.
Okay, 8 is yet to be issued notice. First up, in view of the above, notice be issued to the newly impleted respondent number 8 through registered post with AD within 3 working days, returnable by 3 weeks.
Obliged.
Item number 5.
May I please, Lordship? Well, this
Yes.
appeal is directed against the judgment and award passed by the Land Tribunal Aizol in MSCT number 33 of 2023, my lord. This is the third appeal against the said judgment and order.
Why?
In fact, earlier the claimant has filed an appeal against the said judgment and award, which
was
is
it
registered
disposed?
as MAC Appeal number 17 of 2025. And insurance company also has filed an appeal, which is registered as MAC Appeal number 21 of 2025.
They should have just filed this thing, cross objection.
My lord, and the present appeal is filed by the owner of the vehicle. So all of them are.
So why different? The first this thing appeal
My lord.
Based on that, cross objections could have been filed.
Could have been filed, but at the
So why
same time, my
did-
lord, since the claimant and, no, the present appellant being opposite party in the court below,
so you could
our grievance is against the co-defendant, co-opposite party. So it may not
Who
be
did not file
practical.
an appeal, who did not
That is
file
why
an
we want
appeal.
to file an appeal, my lord.
Okay. So
And
the
while-
co-defendant did not file the appeal.
No, the
But
driver.
but it is against the judgment and order,
Yes,
isn't it?
my lord,
So if
my
it is against the judgment and order, whichever portion of the judgment and order,
My lord.
based on that, you can file a cross objection.
Yes, my lord. Anyway, my lord, since all of us file those appeals may be clubbed together.
We will club them together, and then I think because it will be a bit difficult. See,
matter can be
when
heard.
the first appeal is there,
My lord.
based on that appeal, if it's against the same judgment, the insurance company, who filed the first appeal?
Claimant
The claimant.
for enhancement of the compensation.
Award,
my lord.
isn't it?
Yes, my lord.
So then, if it's for enhancement, then the insurance company should have filed a cross objection against assailing the judgment.
Yes, my lord.
And then even you could have filed another, because you must have been made a party also
Right,
in
my
the
lord.
appeal.
Yes, I was a party to those two
Then that's the
cases.
correct method.
Anyway, my lord, this
It will become
make
a bit
appeal number
difficult.
17, 21, and the present appeal 22 may be clubbed together thereafter. My lord, my main grievance as owner of the accident vehicle is that the claims tribunal.
No. You file your cross objection in the first appeal, and then in the second appeal filed by the insurance also, we'll tell them when the matter comes up. We can't take different appeals like that. That's not done, isn't it?
That would be easier
So,
for
so
us,
you,
but
no. So you withdraw this and you file your cross appeal, whatever portion of the judgment you're unhappy with.
I am yet
in
to,
one.
I am yet to receive a copy of the appeal petition because the same is sent to the address, residential address of the owner of the vehicle, my lord.
But you are the what?
I am the owner, of course. I am yet to receive.
Then you receive that, okay. Instead of making it so many duplicacies, because writing a judgment also will be a problem then, isn't it? How to go
Well,
about
that is true, but-
different steps. It will be difficult. So
There are-
then,
there are
when the
two-
matter comes up, okay, when the matter comes up in the main appeal, after you file your cross objection, then you mention about the insurance. Then we will tell the insurance also to withdraw appeal, fresh appeal that is made, and they'll also file a cross objection. Then in one single judgment, we can dispose of the whole matter.
That is true, my lord. But
We'll consider your cross objections.
the three appeals also can be clubbed together and
No,
can
no,
be
no,
amalgamated
but
together.
that's not how it is done. Same judgment, isn't it?
Same judgment, of course,
Yes,
my lord.
yes. Heard Mr. L.H. Lian Shima, learned senior counsel, assisted by Ms. Ruth, learned senior counsel for the appellant, assisted by Ms. Ruth Lalwatfeli, learned counsel, full stop. The learned senior counsel submits that since there are two appeals pending against the same judgment and order
Dated 21/8,
dated 21/8/2025,
Five.
passed by the learned
Tribunal ISO.
the member cum presiding officer MACT ISOL in MACT case number 33/2023. He may be allowed to withdraw the instant MAC appeal and file a cross objection in the connected MAC appeal filed by the claimant registered as
Make appeal number 17,
MAC
2025.
Appeal 17 of 2025. Praise allowed. Accordingly, MAC Appeal number 22 of 2025 stands disposed of on withdrawal. Yes.
Obliged.
Item number 6.
Respondent government is yet to file affidavit.
Yes.
This is the second time only, madam.
Okay, we'll give them some more time. You're taking steps?
Yes, Your
Which
Lordship.
department is this? Have you contacted the concerned department?
Yes, Your Lordship. I've sent my letter regarding seeking pairwise comments.
To which department?
Your Lordship, there is DC also and PWD as well, Your Lordship, if I'm not mistaken.
And which department?
UD,
Ah, UD and
UD and PA,
PA.
yes, Your Lordship.
revenue.
So I'm just wondering, do you know whether you're taking steps? You contact this thing, person who is in charge of cases. I think they call it, what do they call it? The concerned, there's always one officer, either it's the undersecretary of the department who are in charge of court cases. Contact
Your
that
Lordship.
person.
Yes, Your Lordship.
Mr. L.H. Lianchima, learned senior counsel for the petitioner, is present, along with Ms. Lanun Tui, learned government advocate for the state respondents. The learned government advocate has prayed for further time to file their counter affidavit. In view of the above, list after the ensuing vacations.
Much obliged, Your Lordship.
Obliged.
Item number 7.
The counsel for the petitioner, Mr. Lodbig Hamze, instructed me to make a mention on his.
Your Lordship is absent and has submitted a letter of absence as well till the
Okay.
5th, my lord.
Okay, none appeared for the petitioner, and it seemed that the learned counsel for the petitioner has taken leave of absence. Okay, no, Mr. So-and-so appears on behalf of the learned counsel for the petitioner, Mr. Lalpiaknung Anhapte, by submitting that the learned counsel has taken his leave of absence. Okay, then full stop. Then Mr. Samuel L. Changte, learned, you're appearing as what?
Standing counsel, my lord, for respondent number 2.
Learned standing counsel for respondent number 2 and Ms. Zairam Sampui, learned CGC, have both prayed for further time to file their counter affidavits. In view of the above, list after the ensuing vacations.
Deeply obliged, my lord.
Item number 8.
Yes, this is an IA for condonation.
My lord, the photocopy of the impugn order is at page Roman 1 to 6, and the decree is at Roman page 7 to 10. And the application for condonation is at page number 1 to 8. And explanation is given at para number 2 to
How many days delay?
304 days.
How much?
304 days.
304 days, huh? Yes, what is the reason?
Lordship, the applicant purchased one RCC building on December 12, 2022, which is covered under LSC number 1025/12/01/514 of 2005. He purchased the said landed property from the opposite party number 2 herein. However, without the knowledge of the applicant, the building purchased and occupied by the applicant seems to be ordered and decreed in favor of the opposite party number 1 by the Civil Judge Senior Division 3 Aizawl in its order and decree dated 25.
Wait, the building purchase, okay, it seems to be order and degree. What does this mean? He's occupying the
first-
building.
At first,
Okay,
he was not aware that the order and decree was passed.
Seems to be order and degree in favor of opposite party. Okay. While we
The
are
order was
occupying
passed,
that,
passed
okay.
based on a compromise agreement. If I take your lordship to page number, Roman number,
Okay, so this
3A of the-
property, okay, wait, this property purchased by you was a property which is mentioned in civil suit number 40 of 2023.
Yes, my
We
lord.
didn't know about it.
Yes.
So when did you get to know about that?
on April 4th, 2024.
No. So judgment and degree was 25/9/2023. Okay.
Yes.
So the judgment final order was in 25/9/2023. Then what is this again? Final order 04/04/2024.
Your lordship, in this connection, it may be submitted that the applicant gained knowledge about the institution of the case and the final order passed by the Land Trial Court on 4/4/2024. In this
Okay.
connection, it is submitted that in the last part of March 2024, some person seemed to be the lawyer engaged by the opposite party number one approached the applicant in his house by telling that he and his family might need to be ready for moving out from their house from the second week of April if the opposite party number two still fails to make repayment of money on 4th April, and they feel that the Honorable Court may pass order for looking the two RCC building, including their residence. Hence, the applicant aware some dispute exists where his building was involved. He therefore consults a lawyer who advised him to follow the opposite party number two secretly to the court for gaining knowledge about the actual condition of parties of disputes. Accordingly, on 4/4/2024, the applicant, by following the opposite party number two up to the court premises, District Court Aizawl, come to realize that the opposite party number one had already won civil suit number 40 of 2023, and now an execution case number 16 of 2024 is pending before the court for payment. Then, after having such knowledge, the applicant engaged counsel who firstly inquired the documents available on records, and after having some knowledge that the LSC number 796 of 2008, purchased by the opposite party number one from the opposite party number two, is vacant land, and the two RCC buildings appearing the compromise agreement dated 6/9/2023, signed between the opposite party number one and opposite party number two, and order and decree dated 25/9/2023 in civil suit number 40 of 2023, situated and located in another LSCs.
What's the name of this council? Learned council. Okay, you're the one, you're the council.
Mr. Simon Lena.
Okay, not you.
Yes.
So the applicant did not engage you initially?
Yes.
He had
yes, ma'am.
engaged someone else. Okay, no, I'm just the steps that you have taken, or it's someone else?
Yes.
So it's someone else. Okay.
Someone else, yes.
Then?
And as such, the Land Council firstly approached the Land Council for the opposite party number one sent for transferring the same to any other person and could not mention in the said compromise agreement. Since the applicant is affected by the order and decree as well as the compromise agreement, he is one of the necessary parties to be impleaded in the case. And in order to implead as party, it is possible for the applicant to file review application before the same court. Besides, during the conversation, the Land Council for the opposite party number one also fairly stated that if the personal inquiry is correct, filing of review petition may be good even for them to have affirmed and re-examined their case on its merit, and there would be no prejudice even for the opposite party number two. Hence, the applicant filed review petition number 9 together with CMA number 297 of 2024. The CMA is application for condemnation of delay. That unfortunately, the review court had dismissed the review petition by its order dated 26/9/2024. And after the court dismissing the review petition, the Land Council applied certified true copy of Yung order on dated 1/10/2024, and during such 1 week holiday pusa vacation falls, and the same was finally issued on 16/10/2024. And the Learned Council prepared memorandum of appeal and filed this application for continuation of delay on 22nd.
So are
date.
you appealing against the review, this thing, petition or what?
The appeal is against the main decree, and the
No, but-
subsequent review order is also put to challenge.
No. So you're this saying condonation of delay will be against the review petition only.
No, my lord.
It has to
The
be,
impugn order 26/9/2023, that is ordering decree in civil.
no. See, you have filed, you have gone to the review court to review that impugned order, the judgment. Then your appeal will be against the order of the review court. We cannot jump aside that. What happens to this order then?
That dismissal order is also put to challenge in the main appeal, my lord. Because there are some rulings that only the dismissal order of review cannot challenge without challenging the original order.
So your main this thing will be against the review court and the order dated 26/09/2024. Okay, and along with the review, this thing challenging the order of the review court, then you can mention that other case. So your period of limitation will be counted from the date when you challenge the order of the review court, this one, 26/09/2024. Okay, you're challenging this dismissal by also mentioning that dismissal is being challenged because you want to consider the trial court, which is at 25/09/2023. So this thing will be the 26/09. Dismissal will be challenged because the review court, you feel you're aggrieved by dismissing the review court's dismissal, isn't it?
Yes.
So you're going to, this thing,
My lord. that
your
is why
grievance is against 26/09/2024. But what is it that you want to be reviewed? You want this order to be reviewed, 25/09/2023.
Yes.
So the main thing is the 26/09/2024. So your limitation will count from here. Okay, and then you will mention that in your review petition, you had wanted to review this order, the Civil Code 25/09/2023. We cannot brush aside this 26/09. That is very important. Because then if we set aside 26/09/2024, then the Learned Trial Court is going to consider your prayer for reviewing 25/09/2023. This court is not going to do that. Understood? So you make the necessary amendments to your, because then it cannot be how many days? 300 and something days. It will be less.
Yes.
Are you getting my point? I think that is how it should be.
My lord, if I may make one small submission,
uh-huh.
the applicant herein has not challenged the review order.
So he should order a challenge. That's
in
what I'm
fact-
telling you.
Yes, that is a whole different case.
Hmm.
In this particular case, the applicant has challenged the order that was passed by the civil court in civil suit number 40 of 2023. This is at page number 1, Roman number 1. And even if your lordship could kindly come to the cause title of the instant application at page number 1, it says that this is an application under section 5 of Limitation Act for condonation of 304 days. In
That's what
filing
I'm telling him.
against
But in his
Yes.
application, he has mentioned this review order, isn't it?
this,
So,
I have made my reply, my objection, saying that this cannot be a ground taken for explanation as to why there was a delay in challenging the order that was passed in Civil Suit number 40 of 2023. So if, my lord, if the applicant is to challenge the order passed in the review, passed by the review court,
Huh.
then
Then
a
that
whole-
does
a
the
whole different-
appropriate,
a whole different case will have to be filed,
Yes,
my lord.
yes,
And-
yes.
And this, that.
So I
this-
think,
This instant case will have to be
yes.
dismissed, my lord.
Yes, so I think you can pray for withdrawal. Just withdraw your present this thing. Come afresh, challenge the review. And that you will mention the review, and in the review petition, you have prayed for reviewing the order dated 25/09/2023, which was not allowed. Okay. So you go like that. I think that would be the a more appropriate approach. Because we cannot ignore that there was already an order in between. In between 25/09/2023 and your appeal, there's an order of the trial court, which cannot just be brushed aside. We have to consider that, isn't it? So you appeal against a review by mentioning that you want this order 25/09/2023 to be this thing.
Appeal is also made against the review order is also, there is appeal in the memorandum of appeal. The review order.
You will, so in the review court, you had appealed against this order, isn't it? 29 so and so. So you're unhappy with the dismissal made by the review court, isn't it?
Yes.
To review his order. So your appeal will be against the dismissal of the,
Appeal is against both orders.
yeah. So, see, you want it to be reviewed, isn't it?
Yes.
So now the same trial court had dismissed the review petition.
Yes.
Okay, that is 2609 on 26/09/2024. So unhappy with the
After
dismissal.
Dismissal order, there is no delay while filing the instant RFA.
Okay.
The review.
From
petition was
26/09/2024, there's no delay.
dismissed. There's no
Okay.
delay. It was filed on 22nd October 2024.
When did you file this thing appeal?
22nd October 2024.
October.
Review was dismissed on 2026.
Okay, so this thing, condonation of delay is not required for the review order. But you are unhappy with this thing, order, review orders court, isn't it?
Yes, unhappy
the
with
dismissal.
both the orders. As the applicant brought new grounds, new evidence before the review court, but the same was subsequently dismissed. He had purchased the said building, the suit building, on December 12, 2022. That is prior to the institution of the
So,
civil
but
number 40
the
of
appeal has to
2023.
be against this thing. You're dismissing of the review court, isn't it?
As
Or give me authority. Which authority are you going to rely on regarding the review and the main judgment? Very
I was
limited
preparing only
grounds.
for the IA today.
Okay, we'll fix some other date. We'll have to see this.
Yes,
Okay,
yes.
because here you have mentioned this. Because if the review court has dismissed.
Yes, I have some order that without appealing
Then
against the
have that ready so that we can consider your IA, isn't it? Have your authorities ready so that you can convince this court, yes, because then we'll have to look at the review, this thing also. Review petition also, which, and the order, the review, or the order in the review petition where it is dismissed your pray for. So come more prepared concerning that aspect.
Yes.
Because I think in your written objection, you have objected on those grounds.
Yes, my lord,
that it is a review or something like that, huh? So come prepared with your authorities, huh?
My main objections is that
To
no,
dismiss the IA.
yes, no explanation whatsoever was given, let alone satisfactory. The applicant herein had just stated the alleged facts, which is
No,
otherwise
let
which
him
otherwise
just
cannot
huh,
be considered.
Let him
in the,
convince the court
delay application.
regarding the review. Okay. The authorities which you say I have, you have. Okay, and then we'll see. Mr. Sankling Liana Silo. Yes, pardon? Okay, Lalbia Tuama, Learned Counsel for the applicant. And also heard Mr. Tila Zekima, Learned Counsel for the opposite party. On hearing the submissions made, the Learned Counsel for the applicant has prayed for another dates to produce the authorities he wishes to rely upon. In view of the above, list the matter. When do you want it?
Maybe next Monday.
Pardon?
Next Monday, possible.
Okay, in the next week?
Not Monday.
After the ensuing vacation?
After the vacation?
Yes.
Okay. Is the matter after the ensuing vacations? Yes.